the agenda as it's written, I think, because we have our AV equipment up and running. Our chair, our standard chair, Patrick Carroll's not here. We do have the minimum 4 people for a quorum, 4 board members for a quorum. So we will need to appoint an interim chair for this meeting. Does anyone want to volunteer to be chair? Not everyone at once.
Well, Mr. Langhorn did such a good job last time. I think that he ought to do it.
Yeah. I see it coming. It's mine.
So does the board want to take a quick vote on Mr. Langhorn serving as the interim chair?
I vote.
All in favor?
Aye.
Opposed? Take it away.
Thank you. Am I heard from here? I'm not sure. My ears are still buzzing. In any event, bring this meeting of the Fire and Building Code officials, Fire and Building Code Board of Appeals meeting to order. I'll start with a roll call. James Langhorn, here. Bonnie Elliott.
Here.
Patrick Carroll, absent. Ken McClellan, absent. Juliet Sponsel. Here. Vincent Wood. Here. Marcia Zillis. Okay, so I declare quorum. Do we have some general business to cover before we move? Yes. Right now we're due for public comments, so we'll try to hold those comments to 2-minute intervals per speaker. We have some speaker slips?
We do, Mr. Chair. However, I think these are for items. So
Gotcha.
yes,
Okay.
they are. These are for the item number 1. So the comments now that public comment we're looking for now would be items that are not on the agenda.
All right. Any further public comment? Thank you. Hearing none. We'll move on to the approval of the minutes for the Building Fire Code Appeals meetings for both February 8th and April 7th of 2016.
And Mr. Chair, board members, the February 8th minutes we're still working on. We're trying to resolve some of the recording to make sure we get accurate minutes before the board. But the April 7th minutes are in front of you. So, Mr. Chair, we'll need a motion from one of the board members to approve the April 7 minutes.
I make a motion we approve the minutes from April 7th.
Second.
Have a motion and a second. All in favor?
Aye.
Aye.
Opposed?
Okay,
Motion carries.
Mr. Chair, I do have an announcement. I have a city attorney representative. John, here. John, you want to introduce yourself?
Afternoon, Commissioners. Speak a little louder then. My name is John Doimus. I'm a deputy city attorney here. Mr. Colon, our city attorney, couldn't make it. He's away, so I'm here to represent the city attorney's office. In regards to this appeals before you, I will act in terms of my role will be to, if you have any procedural questions, matters in terms of that, I will guide you through the appeal process for this hearing before us today. I don't act as an advisory role on the subjective matter of the appeal, just in terms of the process. Thank you.
Thank you, Mr. Chair. And the reason that we asked Mr. Doimus to join us is because the nature of the appeals are decisions of mine, so it's pretty awkward to be the secretary to the board trying to help with running the meetings and then also giving a staff presentation. So we thought dividing those duties would be the most prudent way to approach it.
Okay. We have another general business statement here. Announcements and requests for changes in agenda item order, continuance and withdrawals. The one that I did pick up was the El Solito proceeding, the 3732.
Mr. Chair, we were going to propose that, but we've got the AV equipment working, so I think
all right.
We will continue with the agenda as it's published.
Okay. So let's pull subject item number 1, 3732 State Street, and appeal the building officials code alternate approval. It's requiring a board decision.
Thank you, Mr. Chair. For the record, I'm Andrew Stuffler, the building official for the city, and this is an appeal was filed on a decision that I made on April 19th of 2016 relative to separation of a path of travel or accessible route of travel in a vehicular way. So Mr. Doimus from our city attorney's office can give the board specific advice on the role the board plays. I'll provide you with, I'm going to stand on my statements that are in my staff report. Actually, my decision was on March 29th, excuse me, but April 19th is when I published the staff report, and I'm going to stand on the statements in that staff report. I would like the applicant who submitted the appeal, or the code alternate, I'd like to give the applicant an opportunity to further explain their approach to alternative compliance, if it's okay with the board.
Yeah. That's fine. That's fine.
Mr. Chair, is that okay for you?
Yes, go ahead.
Okay, thank you. Mr. Cornell, I think, is going to represent the applicant for the permit. And you can use this microphone if you would like to. Oh, or that one. There you go.
Chair Langhorne, members of the board.
Thanks, sir.
Good to see you. We requested this code alternate based on plan check correction relative to the Sandman project to install truncated domes at the vehicular way pursuant to the latest code provisions in the California Building Code. And what I'd like to do is explain to you here, if you can maybe all take a look at my plan because I don't have this on the screen, what our intent is. And I want to start by telling you what the concept of this housing development is all about. We have done a couple of projects in town. One was the Villa Del Mar project down by on Yananali and Santa Barbara Street. So there's the little Metropolis deli on the corner, and it's a little 40-unit project. And there, the driveway system that leads to all the units also serves as basically the pedestrian way. And this is a concept that goes back to Europe. And I have this first image that you see up here. It's a concept that really started in Europe and was developed primarily in the Netherlands, and hence the name Woonerf. And I will read from something of what a Woonerf is, and what it is in our language of Santa Barbara, it's really a paseo, but a Woonerf is a street or square where cars, pedestrians, cyclists, and other local residents travel together without traditional safety infrastructure to guide them. Also sometimes called a shared street, a Woonerf is generally free of traffic lights, stop signs, curbs, painted lines, and the like. So you see in this image, this is a place where bicyclists and buses and pedestrians basically all share the street. And it's a very important aspect of creating livable communities, which is what we're trying to achieve here. If I could see the next slide. I think you just have to probably push the advance button.
Is it like next page? Or?
Probably, yeah. It's
Okay.
probably just there you go. So this is another project we designed, actually going back to 2007, but it was built in about 2012, and that is the housing project for Cottage Hospital up at the old St. Francis Hospital. It's called Bella Riviera, and here you see this notion of a Woonerf, or a shared street, where the people using this as well as the cars are all together. In this case, you can see a similar application of what we're proposing on the project that is before you today, where we do delineate on both sides of that shared street, which also is the fire department access. So this is the 20-foot wide fire department lane that's required for emergencies, where we have delineated sort of pedestrian ways on the sides, and we put in a little pebble strip, which is what we're also proposing here, that helps to create a differential and allows for safety. But the important thing here is that the way this functions and the way these Wooners function is that the pedestrian in this right-of-way is really the priority, and that when cars come through here, they they see the pedestrian, they drive at very slow speeds, and everybody knows where everything is. It's not a traditional situation where you have a vehicular way and you have a situation where you have to cross that vehicular way where cars are traveling at 35 miles an hour or whatever. It is, again, a shared street concept. So let's just go through a couple of other examples of that, and then I'll focus on the plans. If you can jump ahead the same way we did before to the next. So that's fine. Here's another image, and then the next image. Again, you can kind of get a sense here where there's very, very little automobile traffic, where the pedestrian really is the priority. And then the next screen, the next shot would be a similar example. If she can click that, there you go. So here again, you see where you've got bicyclists, pedestrians, etc., in that same roadway. So that is what our concept is. So let me let you focus here on the project itself so you can get a sense of what it is. This is State Street, where the old Sandman used to be. And if you've been up that way, you've probably noticed that it's actually been demolished and is ready for construction. So we're actually in the final stages of obtaining a permit. Along State Street are 3 commercial buildings and the entrance to the parking for the commercial buildings and then the residential portion of the project. There are 72 units that are in the rear portion, and then the small commercial buildings up front. So in front here, we have, for instance, State Street and State Street sidewalk, where we have the conventional truncated domes that are required by code at sidewalk breaks. We have another sidewalk break here where we would have those truncated domes. And throughout this application, we have the typical application of a truncated dome, where a pedestrian would know if they're going into the vehicular way or the parking lot and the like. At this point right here, we actually have, and I didn't bring an image of it, but it is essentially a gateway. It's a large sort of trellised structure that identifies that you're going into that residential portion. It's a gateway for the automobile. And at that point, we are essentially indicating the transition to this Wooner system. And this is a 20-foot wide road to comply with the fire department. And it is pretty much as I showed you, and let's go back to that second slide if you can do that for me. It's pretty much almost identical to what we did at the project up at St. Francis, where we created these different paving textures, and we are using the pebble strips around the perimeter to help delineate essentially the safe areas of passage for the pedestrians when an automobile would be coming through. This is a one-way circulation system, by the way. It's not two-way, so you have cars only going in this one direction. And the idea is that once one passes through this portal, they are in that shared street system. And our feeling is that because this isn't operating in the sense of a traditional a traditional vehicular way as the code defines it, that this is a sensible application. And this really works, because what happens in these situations is cars drive at very slow speeds. They're aware that pedestrians are there. It's intended to be a place where kids can play in the street and cars will respect them, that you don't have high-speed travel going through here. Now, if I were to meet the letter of the law based on what we want to do here, I would either have to have curbs all the way around here and then curb cuts for accessibility to cross this street, or the alternative would be to literally rim the entire site with yellow truncated domes. And that would be 3 feet wide. And for us, that's probably an unacceptable, not only aesthetic solution, but in reality, because of the widths that we're dealing with here, the truncated domes take up so much of that shared roadway that cars driving would always be driving over the top of the truncated domes. So the alternative for us, frankly, if you side with the appellant and in lieu of agreeing with Mr. Stuffler's decision, we will end up having to redesign the circulation system of this site, not allow the pedestrian use of this roadway, and just create crossings intermediate around and put in the truncated domes, and that would be the solution. We think that this is a safe, appropriate solution that is going to create a wonderful living environment for the people that are going to live here, and we have examples of how it is working well today, not only here in Santa Barbara, but in numerous other communities really throughout the world. So I think that pretty much concludes it. I'll be happy to answer questions.
Okay, thank you, Brian. The board will hear our report and the appellant's report, and then can ask questions of us as they would like. So, I just want to, I would like to sort of refresh the board's, or give the board an idea of what is being appealed, because the appeal form that was submitted was a little confusing. It talks about ratification and decisions not warranted under the applicable codes exceeds waiver accessibility. So there's been no ratification and there's been no waiver. I think what the appellant was contesting to, and Will's here, he can tell us if I've got this right, but I think he just doesn't agree that my decision that what is proposed is equivalent in, what were those categories? Durability, fire resistance, effectiveness, strength, quality, and safety. So I think that's really what he's appealing, and if I've got that wrong, he can straighten me out. And I think Mr. Doimus can give you more guidance if necessary. So,
if I just add, the current motion before the board right now is Andrew, the chief building official's decision in terms of this code alternate, in terms of this Warnoff application, and if this application, this alternate code application, can be approved. So his position to you is that it should be. The appellant is now allowed to respond, and then you are to make a decision. You can consider alternate decisions as well, and your decision is final. It's not appealable to council. So that's in terms of that. So I guess the next, unless you have anything else to offer, I guess the next subject is to let the for the chair to recognize the appellant and allow him to proceed with any rebuttal today.
Mr. Stuffler? Okay.
Whoops. You made it go away.
Oh, thank you.
Good afternoon, Chair Langhorne and members of the board. Mr. Stuffler, thank you for being here. Mr. Doimus from the City Attorney's Office. I'd like to also recognize Mr. Kernal, who I admire very much, as the architect who just spoke to you. The attorney for the owner is here, Mr. Fell, one of the truly eminent real estate attorneys in the area. Former Chief of Plan Check, Mr. Hansen, and the current Chief of Plan Check, Ms. Cassidy, and the current Chair of the Access Advisory Committee, Mr. Burnham. I really really appreciate everybody coming out for this discussion. As you all know, I've come to the board several times since Mr. Stuffler rejuvenated it at the beginning of last year. And I have, I believe, pretty much uniformly been reaping praise upon him for the work he's done in doing that and having these constructive discussions on accessibility. So I don't think that the fact that we decided to come forward with this appeal changes that at all. I think that if I guess I just want to sort of remind the board and audience of something they wouldn't necessarily otherwise know, which is that I agree with Mr. Stuffler's decisions the great majority of the time. I did feel that this one was important enough and enough of a precedent that I was concerned enough to bring this appeal to you. The next thing I'd like to say is I appreciate the challenge of citizens serving on an appeal board like this. And, you know, there's certainly multiple hats you have to wear, and you'll have different areas of expertise. I'm here today to focus on the code, and some of you know the code better than me, far better than me. Others who are like me, a beginner, please don't be intimidated. These particular code sections really are plain language, so we'll start with that in interpreting them, just the plain words. And if when things get a little technical, it'll only be as necessary. So Accessible Santa Barbara is an unincorporated nonprofit association, and we're small. I have been its public face, and we get a lot of tips from people who are disabled and have concerns, but also receive services from the city. This is a small city, and so I see a constructive role to play in being the public face on speaking on these issues. I'd also like to make it clear, because I think sometimes all city boards, and this one too, will sometimes have someone come to you on an issue, and you know their real issue is something else. Okay, like maybe they don't like the project, period. And I want to make it clear, I knew nothing about this project before I started researching this issue. We monitor the filing of permit applications, including code alternates like this one, and pretty promptly upon noticing that this one was requested, I did send in an email to the city to try to get some information, but the decision was made before we had a chance, before we received a response. And I understand that this project has been through many years of design review and planning commission, and in doing the research, I could see that there were some people that had some concerns, you know, with the project, but I was not one of them, or even really in contact with Santa Barbara at that time. I should just for the record note that my permanent residence is actually San Francisco, and I have family here that brings me here on a pretty much a frequent basis. And this kind of work is something that I'm unable to do in San Francisco because of my day job as a paralegal, and I don't have any such conflicts here. So I am happy to have this opportunity to play this role in your great city, which couldn't contrast more with my hometown of San Francisco. code-alt proposal, and I will try to make this as large as possible, and I will also try to describe anything that I can as fully as possible for the benefit of people who are vision impaired. I apologize in my sort of failures here. I'm not very technical, and so I think it's appropriate to let me just state my overall theme. You heard some wonderful aesthetic advocacy from the preeminent architect in town, and I'm very sympathetic to that point of view. I think Mr. Cornell, besides being a top architect, has the soul of an artist and wants things to look nice. And one of the things that does happen in accessibility is that it is law. It's law that is much larger than just Santa Barbara. It starts with international codes, the national code, the Americans with Disabilities Act, the Fair Housing Act, and then the state of California, through the Building Standards Commission, will adopt an international code on accessibility. They went their own way and created our own accessibility code, which is in many ways stricter than the ADA. But it is the law. Santa Barbara does a local adoption of every 3 years. They call it the triennial code, and it's a city's only allowed to make their code stricter. They're not allowed to make their code more lenient on an accessibility or any issue, really. So so the fundamental principle, a building code is a regulation. There are some things that are statutory, but on the whole, it's considered a regulation. And the agency that is charged with interpreting any regulation gets a great deal of deference and leeway in their determinations. Mr. Stuffler makes more decisions by noon probably than I make in a week, and
Hey, can I make a point? I think that 10 minutes you've been talking, and I think we only give people 2 minutes. So I think it's time to get to what you want to tell us.
Well, hold on. Can I make just a correction, Deputy City Attorney John Domus? This is actually for due process purposes. They get more than 2 minutes because it's the appellant's part. I understand and I appreciate what you're saying in terms of getting to the point, in terms of moving on, in terms of time constraints. This is something that can't be continued over. Decision needs to be now. So I'll make that encouragement to Mr. Wheeling. But there's just for the record, I wanted to clarify there's a little bit longer period of time because it's the appellant's brief. So, but I do encourage in terms of bringing forward your argument for the commission's, for the board's sake. Thank you.
Okay. Chair Langhorn and members of the board, particularly Mr. Wood, I apologize if you're not finding my discussion constructive. I believe that this is a very important issue. I have put a great deal of time into analyzing the statute. Both the city and the property owner are in danger of making a mistake, in my opinion, and as the appellant, I do have the burden of proof. I feel like an amateur boxer up against a heavyweight champion of the world, and also someone who I happen to admire so much, and yet the burden of proof is on the appellant to try to demonstrate that we're not here wasting our time today, that actually there's a legitimate legal issue here that you need to be aware of. Now, with only 4 members of the board present, I recognize that Mr. Stuffler's, the city's decision stands unless there's a supermajority of 3 votes to overturn. So I'm realistic about that, but I do respectfully insist on the opportunity to at least cover sufficient code issues to rebut the assertions that have been made in favor of this application, because there are numerous. So with that, I'll continue. The applicant's application for a code alternate mentioned several rationales for granting it. One is, quote, the July 1st, 2015 mid-cycle amendment 116.5A requiring 3 feet of truncated domes separating a drive aisle from walk path sidewalk. Now, it goes on to state that the head building official, George Estrella, and I'll interject here that Mr. Stuffler replaced Mr. Estrella about a year and a half ago, quote, okayed the use of combining a drive aisle with a walkway on January 6, 2014, if separate materials are used, including a 1-foot pebble strip. The Braille Institute supported what we proposed. The entire project was designed and approved based on their decision, and our first building permit was applied for 6 weeks before the code change. Now, each one of those statements is rebuttable with evidence that I've brought with me today and law that I've brought with me today. So I appreciate your indulgence. I mean, if we need more time, but I'm going to do my best, given my, obviously, I'm not, I'll never be Daniel Webster, but I'm going to do my best. I'll just quickly address their attaching emails from Mr. Estrella to their application from 2014. If we're correct that this decision does not comply with the code, what the former chief building official said a couple of years ago is really not relevant. In other words, a city official does not have the authority to bind the city to future code changes through an email. No official of a city has the authority to waive the city's future rights to enforce the law as it changes. And as you'll see in a minute, the law in this case did in fact change during the consideration of this discretionary review prior to the filing of any building permits, which is, I understand that's contrary to what the applicant stated in their application. So the comments were supplied, it indicates by Chris Hansen, CASP consultant. Mr. Hansen is the former head of Plan Check for Santa Barbara. He's a certified CASP consultant. I understand there have been other experts involved, but he is now representing the applicant. Now, these comments are quite to the point and would be dispositive. We could all go home if they were true. That the section 1116A.5 came into effect on July 1st, 2015. As the first permit for this project was submitted May 20th, 2015, this application requires this section requiring detectable warnings between a pedestrian path and a vehicular way does not apply. I'll show you in a minute why that's not true. In response to something that Mr. Kernell said, there's a reason why you've never seen a project with a driveway the way it was described, what they would have to do if the appeal was upheld. Essentially huge yellow stripes bordering both sides of the driveway. And that is because projects typically provide a sidewalk for pedestrians, and that should have been done here. It was a choice not to. And what the code actually says, and I'll show you in a moment, is that unless there's a separation by a curb or rail or other element, then you need to do these unattractive yellow domes, admittedly unattractive. So that is the normal solution. Okay. In the project site plan, there are some very important and relevant things apparent. It's a 4.5 acre site. in which there are going to be 13 buildings built, 10 of them multifamily residential, 3 of them on State Street will be commercial. So this pathway is the main transportation thoroughfare through around the project and back out. The primary entrance is at the top, at State Street. And so one of the concerns we have is that this project is multi-use. Parts of it are commercial property, which presumably will be public accommodations under the law. Parts of it are multifamily residential, which normally would not be public accommodations under the law, but they can become public accommodations. So you have different code sections, unfortunately, that apply. This section I was just discussing, 116A.5, that is from Chapter 11A, which is the governing code for residential buildings, residential areas. So it's important to note that this code alternative, if it is allowed to stand, it's at least unclear whether that is going to extend to the commercial parts of the property, which are clearly are covered by 11B, which has its own requirements for protecting persons with disabilities who are using the property. The commercial properties have been designed. This property will be split into 4 lots, 3 commercial and 1 large residential. It is, from what I can tell, impossible to use the accessible features of the commercial buildings without traveling on the residential parcel. And I'll show you that in a minute. So, today I'm looking for every way possible to try to keep my presentation as short as possible. And so one of the things I'm going to drop is that issue, other than just to point out that it's going to be a thorny one for this project going forward if this alternative is going to be also applied to the areas of commercial use and public accommodation. It is possible, by the way, okay, well, I'm sorry, let me stop right there for a moment. Mr. Stuffler included in the agenda package the wording of 11B-103. That is the equivalent facilitation grounds, and that has been presented as an alternative grounds for the code alternate, in addition to the 104.11 equivalent materials, essentially. So 11B-103 equivalent facilitation, since it's 11B, this would apply to the commercial parts or the commercial uses of the residential part, and it talks about that you can approve alternate designs, products, or technologies, provided they result in substantially equivalent or greater accessibility and usability. And there is a tremendous amount of literature. I'm not going to get into it, but perhaps some of the public commenters will regarding why the specifications of the yellow domes are what they are. So respectfully, I believe that when one interprets a code, there's a limit. Interpretations have to be made every day, as I said, but to stretch, to say up is down or red is blue, to hold up a quarter and say it's a penny, that's exceeds the bounds of what's an interpretation, and that respectfully is what's happening here, I believe. And that's why I believe the decision doesn't comply with the law, and that the answer lies in changing the law rather than in sort of interpreting it locally out of existence. Now, Mr. Stuffler also gave you Section 104.11 11, alternate materials, design, and methods of construction. And again, it requires that the approved alternative comply with the intent and provisions of the code, and that the material, method, or work offered is, for the purpose intended, at least the equivalent of that prescribed in this code in quality, strength, effectiveness, fire resistance, durability, and safety. And I would stress safety as a synonym of accessibility. Now, this project actually consists of approximately 13 building permits. And I want to address Mr. Stuffler's statement first, because he's largely correct that in doing the request for appeal board hearing, we didn't, there's some irrelevant, possibly inaccurate things, so let me just correct that quickly. I'm a student of this myself, and as I've learned a lot in the last few weeks, even I can see. The purpose of the statement on a ratification appeal is that you've heard many ratification appeals on accessibility issues this year, last year too, sorry. And this is a classic proper exercise of the building official's reasonable discretion, where he weighs factors, evaluates evidence, and reaches a decision which shouldn't be second-guessed unless it's clearly wrong. This is quite a lot different, in my opinion, in terms of being a clear code that requires certain things, and the exceptions require a very rigorous analysis, I submit, which has simply not been done here, and I believe would be impossible. The project itself consists of about 14 building permits. Several of them are for the grading, which is actually relevant to how your driveway and sidewalks turn out, and then a separate building permit for each of the 10 residential buildings, and a separate building permit for each of the 3 commercial buildings. Section 116A.5, requiring the yellow domes in this situation, became effective on July 1st, 2015. And it is just black letter law that your project is subject to the codes in effect on the day you file your building permit application. Once you get that in the door, you don't have to worry about the codes changing. But the argument was made in the application and continues to be made with the city that because this applicant filed a demolition permit, Santa Barbara requires a permit to tear down a building even, and does the state code, I believe, that somehow that gives them coverage of the obsolete code forever going forward. And that's just simply not true. If it were true, you could tear down this building today, come back in 10 years, and not have to worry about any code changes that have happened. In case I'm not able to find it in time, I'll tell you that the applicable section of the Health and Safety Code and also the applicable section of the California Building Code says that the standards applied to a building permit are applied to the work under that permit. So those 2 keywords are key, and a good example of where I think that you can apply your common sense to this, that permit. So the demolition permit, as you'll see, and as you apply the words that permit, it was to take away the old Sandman Hotel and cart away all the debris, period. So in no way would that trigger the older codes for the subsequent renovations on that property. And in fact, the private consultant who put forth that argument when he himself worked here at the city he did not interpret the code that way, as I'll show you, and when you had sites where the property was cleared with a demolition permit, and then the code changed when they came in with their building permit applications, they had to apply the new code. Okay, so this is a very important picture. I hope some of you at least are able to see it. This is not the final subdivision map, but gives you a sense for what I was talking about with the 4 parcels. On State Street's on the left. The yellow is the residential part. And again, this is a 4.5 acre lot. And as you can see, the yellow extending to the left all the way to State Street, a couple of things are apparent. One, again, that no one will be using. There is a small driveway down below. I may have actually drawn the yellow inaccurately because I think the small driveway at the bottom left of this photo drawing might also be part of the residential parcel. So people will be coming onto the residential parcel on their way to the commercial parcel. And, it's not for us to give advice to the owner, but it is intended to be a condominium project. It's going to be sold to the future owners who will have their condominium association. And I think they should consider on this accessibility issue whether that future condo association is going to be buying into liability essentially. By not complying with the code for the residential part of the project.
Sir, sorry to interrupt, but can I ask you to summarize for us? Can I give you 3 minutes? Because I'm not sure where this is going.
Over a half hour.
Yeah, I'm there, and I'm
Trying to wind this up.
I'm trying to listen, but I'm also doing other things.
Let me go on the record for a second. Deputy City Attorney John Doimas. Due process does require the opportunity to be heard, but that also doesn't have the most effective opportunity to be heard. And also the procedures on the ordinance in terms of Santa Barbara Municipal Code Section 2204 that adopts the procedures for the Building and Fire Board also asks for rebuttals in terms of, I know you're trying to make a rebuttal in terms of overall presentation, but what the commission is asking for in terms of the record, and it is fair, to rebut the building official's assertion that the code alternate in this case is appropriate. So I think that's where, in terms of veering off, in terms of different purposes or the lot size and all that, I think it should be restricted to those specific things. And the commission is more than welcome to at least give an appropriate time in terms of how much you want to wrap up at least beforehand, so the appellant can make his arguments and choose right now. So what would you like in terms of?
I make a motion that he allowed 5 more minutes.
Is requesting 5 more minutes of time?
I'm making a motion, and the board can approve it or disapprove it, that we give him 5 more minutes, and that's it.
Okay. Can I get a second? Okay. I was going to provide 3, but we'll go for 5 at this point, please.
I'm being generous.
I appreciate the time you invest in you're on the board, and I must object that there's been multiple grounds given. I think the record will show that everything I have said has been directly targeted at something that has been put forth as a reason for the code alternate, and the reasons that I've been giving are directly relevant to why upholding this decision is going to cause liability for the city, liability for the owner. It's just simply not doing anyone any favors. So I appreciate your right as a board. You don't have formal rules on the length of the presentation. I appreciate that there's another appellant waiting to be heard, and I don't want to be inconsiderate to them either. But I simply can't agree to just not cover important legal questions. And if you feel that you need to cut off the appellant's presentation here, all I can say is that we'll see if there's anything we can do to try to get back before you. But let me.
Mr. Willie, let me interrupt one second. First, there's a current motion on what I should have corrected, there's a current motion right now in terms of in front of the commission. The current motion is the appeal of the code alternate for the property at 3732. So to do another motion in between would be improper, so that motion can't be done at this point. But I think, Mr. Wheeling, it is fair to at least, in terms of, as you mentioned politely, the time constraints, the fact that there is another appeal behind this, to at least give the commission the idea of in terms of how much further your presentation will be.
I think I have at least a half hour. I'm sorry. There is, you've got allegations that that the code section doesn't apply, that the analysis of that's required point by point on this code alternate, which has simply not been done at all, is an essential issue that I need to get to.
But the one thing the code section does state is it just allows for to rebuttal and I'll quote specifically from there. The chairperson shall recognize the appellant for presentation of rebuttals. So in terms of, if you can just stick in terms of the rebuttals, in terms of what's contained in the written decision of the chief building official to focus on that. I think that's appropriate. That's within the rules.
Okay.
And
all right, I'll focus
go for that.
as the best of my ability, starting this moment.
Okay, well, let's proceed then with that.
We have the language of.
Got 5 minutes then, please.
Wait a minute. I made a motion. It was seconded to give him 5 minutes. I want the board to vote on it.
I understand. There's a current motion right now in front of the board, and the appellant has the right to present a rebuttal. The code isn't in terms of, doesn't provide a time limit. Our municipal code, the ordinance
Sounds
doesn't
to me
provide.
like it's a filibuster.
Well,
Let me.
May I
please,
respond to that?
Please, I have the floor right now. The code doesn't provide a specific time limit. It does for public comment. This isn't public comment. Public comment would be 2 minutes. This is an appellant rebuttal. While there isn't any specific time limit in terms of that, there is a reasonable opportunity to be heard. I do think a reasonable opportunity to be heard would be appropriate in any sense. Whether a half hour in terms of an appeal, for the record, I think is reasonable. And it may not, but you can make a motion. You have the right as a commission to make a motion, and I can open the floor now to that.
Did you? Excuse me. Did you just say you thought that he had the right to make a half-an-hour appeal?
What I'm saying is,
He's already done that.
He has the opportunity. Yes, I understand. He has the opportunity to be heard. And while the rules don't apply, our current rules don't have a specific time limit as to that. What's most important is the most effective. It has to be some opportunity to be heard. The commission doesn't have to make a motion to cut time limit. I think that's inappropriate. You can make a request for the time limit right now, and then that would be the time limit. Going from there.
I really do believe that the speaker should consider what he's heard from us. We have listened for well over a half hour now. We're asking him to try to summarize in 5 minutes from this point that we all agreed to summarize, please. We need this.
And I think that's fair, and that should be the time given.
And I truly appreciate Chair Langhorn, your feelings on the matter. I mean, this is a code issue. I have multiple points that, if they're not made, there's no way to sustain the burden of the appellant on appeal to show that this decision doesn't comply with the law. And I mean, honestly, I respect whatever you do, and I think it might be appropriate to have some sort of rule to give people fair notice in the future. Some boards and commissions do that. City council does that, but I just will do my best to be as quick as possible and to not get sidelined in anything that isn't directly connected to attacking the grounds for this decision under the law. I'm really trying to help the city here, and believe it or not, help the applicant.
And if I may, I apologize in terms, this is my first time appearing before this commission, being familiar with the rules, looking through, so I had very short notice. There are no, like I said earlier, there are no specific timelines. A reasonable amount of time should be allowed. A half hour may seem like a lot, but it's not in terms of a hearing. I think the appellant should at least be allowed to present some arguments, at least for the record. Obviously, if it goes beyond even that period of time, then you have the right to cut that off, but at least to show for the record purposes to let him present his argument, especially since there are no time limits within the hearing. What is considered a reasonable amount of time could be subject to interpretation. If you look at a lot of hearings, they at least go an hour, 2 hours, to allow at least the appellant at least another 20, 30 minutes to speak on this.
You're advising us to go another 20 minutes of this?
I do. I understand the patient, but as an adjudicative body, that's part of the requirement.
Okay, well, we'll have some new business because I don't want to get trapped in this kind of bubble again.
Yeah.
All right, so let's go for 20 minutes per suggestion of county council.
Well, I'd like to know what's going to happen to these patient people back here. They've been waiting for an hour.
I would offer willfully.
Because taken up the whole meeting here. By
Again,
4:30,
sir.
people want to go home. They don't want to sit around and listen to this.
May I suggest?
I'm going to have a parking ticket out there. That's what's I've got.
It's having attended the meeting before last where the appellant went on for a couple of hours, including a half hour by one of their witnesses. I have to object to what I see as unfair treatment. I would suggest as a solution, and that
Please excuse me. That's not your role to advise the commission. We've spent about 10 minutes in terms of arguing. Yeah. Let the appellant continue with the procedure. We take him at his word. Let him wrap up and the time given, and there will be no other objections to that. It'll be a perfect record, and that's how it should proceed. So let's not debate the issue in terms of the length anymore. I think Mr. Wheeling is aware of the commission's frustrations, and we should give him the opportunity to finish his presentation within a reasonable amount of time, understanding the commission's constraints. So let's proceed.
And I'll just offer I'd be happy to pause and reconvene after the other appeal. That would seem workable to me. Okay. 116A.5. An important issue that has been raised on the interpretation of this codes section. And if you note, when a walk crosses or adjoins a vehicular way, the walking surface shall be separated by the vehicle from the vehicular area by curbs, railings, or other elements, or the boundary between pedestrian areas and vehicular areas shall be defined by a continuous detectable warning 36 inches wide minimum, complying with Chapter 11B, Section 11B-705. So there's three essential elements I'd like to call your attention to. First, vehicular way. When a walk crosses a vehicular way, this is an 11A section applying to multifamily residential. The corresponding section of 11B actually has a heading about a hazardous vehicular way, and that argument has been used. It's the core argument of the applicant for this project that code should essentially be disregarded for this project because it's not a vehicular way. Now, they're not addressing the code. They're showing pretty pictures, but this is law. So, I think the city disregards it at its peril. This driveway is a vehicular way. Second, curbs, railings, or boundaries. Again, a sidewalk would cure this problem. Third, there's a specific dimension in this section of 36 inches. So one of the findings that must be made in order to grant this code modification is that what is offered is equivalent in safety and accessibility to the 36 inches wide domes that the code requires. And again, I think the photos it doesn't pass the laugh test to look at what would be required here and what is being given as a model to say, first element of comparison, 3 feet versus 1 feet. Can you find that 3 feet is the same as 1 feet? Now, to me, that rubber band of interpretation that is being stretched has just snapped, okay? This is the equivalent of saying red is blue or up is down. It's just a bridge too far. Finally, on this section, it cross-references to Chapter 11B, Section 11B-705, purely for the technical specifications of the truncated domes. They've already said it needs to be 3 feet wide. Now they're referring you over to the commercial section, just for the public accommodation section, just for the technical part of the codes. Now, this is crucial, that you must find, and the building official must find, that each of these elements is also at least as well met. That the pebble strip satisfies as an equivalent to these incredibly detailed specifications in 11B-705.1. There are 5 categories of them, and each was the product of thousands of hours of research by scientists nationwide. And so to look at some pebbles in a strip and say, I need you to hear what this section says for the specifications, because these are specific findings that you must make that this proposed alternate satisfies. You have to find that it is equivalent to 36 inches, even though it's only 12, in its safety and accessibility. And you have to find that the dome size, you're really going to get mad at me now, but you need to understand how hyper-specific the scientists made this code, and for a good reason, that the dome size is category 1 of 5, okay? The dome size must be at the base between 0.9 and 0.92 inches, okay? Now, I can see people feeling that this is government running amok, but it wasn't numbers they pulled out of a hat, okay? 0.9 to 0.92 inches in diameter. At the top of the dome, the diameter must be between 0.45 and 0.47 inches, and the height must be between 0.18 inches and 0.22 inches, okay? You don't even have the remotest specification for what the substitute is, other than it's pretty pebbles in a 1-foot strip. Second category, dome spacing. The domes shall have a center-to-center spacing of 2.3 inches to 2.4 inches and a base-to-base spacing of 0.65 inches minimum. Now, that is so specific, and you must find that this alternative is equivalent to that. And I don't see any evidence in the record that even comes close to that. I'd be willing to hear, again, and I consider Mr. Cornell a miracle worker in many ways, and they could probably come up with some formula to give some specification that would allow the building official and you to make a finding of equivalence. The third of the 5 technical specifications, required, is contrast. And when I say required, it's required to be met, or it's required to be found as an equivalent facilitation. So Mr. Stuffler was right earlier that I may have used the word waiver improperly in terms of what he was intending to do. The third of the 5 specifications is contrast. And there's a very specific scientific formula for the contrast. The fourth of the 5 specifications is resiliency, that there shall differ from the adjoining surface in resiliency or sound on cane contact. And the 5th and final technical specification is color. The warning surfaces shall be yellow, conforming to FS 33538 of Federal Standard 59C. Now that gets known as called Federal Yellow, and I sympathize with anyone that rolls their eyes and says, "Oh my God, who did this and why?" But I assure you, there were years of debate and science that went into this, and so you need information to be able to make a proper finding that these pebble strips are at least as safe and at least as accessible. So I keep saying there's 5 categories, and I'll just remind you that the width, which was really the first category, is in the section itself. Again, I apologize for having to take all this time. I don't know how else I could have just made that point. Here's a diagram very quickly, just showing how the diagram is actually in the code of the specifications demonstrating them, and you as a appeals board also have the right to grant alternatives, and the standard is essentially the same as it was for the city. And the standard would be the same on any other analysis. The appeals board may consider any alternate, provided that it finds that the proposed design, material, method, or work offered is, for the purpose intended, at least the equivalent of that prescribed in the technical codes for accessibility. If you feel you can make that finding today, I mean, you need to vote your conscience and your judgment, and I respect that. But I just cannot conceive of how that can occur. Given the lack of evidence of any kind on any of these categories, that these pebble domes are at least as accessible. And not only is this an important project here, I'll remind you, but this is new construction. This is not, you have looked at many renovations of buildings where there's every renovation is different. Those of you who worked in the trade know. And, new construction is dirt, okay? There's 4.5 acres of flat dirt there. And if this is allowed for a new construction there, the city, and I don't throw the word liability around lightly, okay? But the next project that comes along and says, we want to do these pebble domes, okay? How is the city going to say no without getting sued, okay? They said it was okay on this 4.5 acres of dirt. How come it's not okay on the 3 acres of dirt across the street? And I think that's something I would hope the representative of the city attorney's office would consider advising you on, but that is between you and him. He advises you and not me. The specific section that the city has invoked, one of the specific sections to justify this alternate is California Building Code, section 104.11. Alternate materials, design, and methods of construction and equipment. So this is where it describes the standard, and Mr. Stuffler has already told you this, and it's in his report, so I can skip over this part of it, although I ask that you consider, again, how specific the requirements are in order to make findings that it is equivalent. As a very important point of interpretation on this standard for approving alternate materials in 104.11, this is a piece of code that came verbatim from the ICC code, the National Building Code. I mean, not every jurisdiction adopts it, okay? Similar like the Uniform Commercial Code, you have a national model code. California, they didn't adopt the accessibility section. They did adopt this section. So 104.11 was drafted by the ICC and was adopted word for word by California and has not been modified by Santa Barbara. Now, the reason I'm telling you this is that when you have a code section that is written by somebody nationally, it's very appropriate to consider what they say their own code means. Again, the code we're using today is verbatim from the 2012 IBC Code and Commentary. And they give the same section. And now I do want to acknowledge that code commentary written by the people who created the code is not binding. Okay, they chose not to put it in the code. It's commentary. But commentary by the people who wrote the code is considered by most courts to be very persuasive authority of what they meant. And so I'm going to skip the code section and read what the IBC says in an advisory capacity, how a building official can grant these alternates under this section. The code is not intended to inhibit innovative ideas or technological advances. Cannot envision. Okay, I'm going to paraphrase a little bit, and tell you what, I'll just skip down to the part that I can quote. The building official is expected to apply sound technical judgment in accepting materials, systems, or methods that, while not anticipated by the drafters of the current code text, can be demonstrated to offer equivalent performance. By virtue of its text, the code regulates new and innovative construction practices while addressing the relative safety of building occupants. The building official is responsible for determining if a requested alternative provides the equivalent level of protection of public health, safety, and welfare as required by the code. It suggests that research reports are a minimum amount of evidence that are needed. Quote from the commentary again, when an alternate material or method is proposed for construction, it is incumbent upon the building official to determine whether this alternative is in fact and equivalent to the methods prescribed by the code. Reports providing evidence of this equivalency are required to be supplied by an approved source. Okay, so that means not sending two people out from the Braille Institute, okay? It means something much more rigorous than that. The ICC Evaluation Service is an example of an agency that provides research reports for alternate materials and methods. And it then goes on to discuss what are appropriate tests that can be conducted. And it's a very rigorous scientific standard. And so I'll leave that alone and go on to the...
I don't mean to interrupt. Mr. Fell was kind enough, like I said earlier, this is my first time appearing before you in terms of this process. So I only had an hour or two to prepare to look at all the rules. Mr. Fell did provide me your appeal hearing procedures, so which is separate from the what's found in the municipal code. And I will quote verbatim. Bear with me, I know you've been patient, that the appeal hearing process, presentation by staff is 5 minutes. The presentation by the appellant is also 5 minutes. Time limits may be limited or extended at the discretion of the chairperson. I think we've gone over 5 minutes. If the chair wants to make a recommendation to allow one more, since I've interrupted, allow 1 or 2 more minutes for the presentation, you may be able to do that.
I've got to interject with an objection.
Excuse me, I have...
Thank you. Can you summarize in 3 minutes, please?
Well, you know, if you're...
3 minutes.
Okay.
The commission...
I need this.
The commission has a
They need
discretion.
it.
They have the rules.
We all need it.
I'll provide you a copy afterwards. It's
Well,
5 minutes.
Where are these rules coming from? Because they're not in the municipal code. They've not been voted on by this board. Are you looking at a city handout from some?
The appeal decision.
I could have prepared differently if I had known anything like this, and it simply, as far as I know, doesn't actually exist as a rule. Well, you know, I'm not a professional at this. I think
this meeting's getting a little hijacked. The commission gave you 3 minutes. The rules are 5. The due process, they've given you 40 minutes. So
I reject that
3
there's any
minutes.
rule that limits 5 minutes, especially since the last hearing I attended, the appellant went on for a couple of hours.
Let it be on the record, the appeal hearing, I provided a copy to Mr. Wheeling.
Okay.
You can see
And
there.
so I'll read into the record that this is a document that has says City of Santa Barbara Plan Encounter, page 6 of 9, appeal process.
Here's the appeal hearing guidance, the first
Okay.
page.
The first page of the document is, again, it's unsigned. It says
You're not the advisor of the commission. The commission has given you 3 minutes, so you can wrap up.
Okay, I am simply objecting that this is
That's
any
fine.
sort of rule that has ever been applied before. I think it's,
Your objection has been noted. If you have 3 minutes.
Okay, so equivalent facilitation was the alternate, another ground given for offering up this, for approving this alternative. And Mr. Stuffler provided you with the code section, but I do think it is helpful to, the words equivalent facilitation in that code section are actually defined terms in section 2-202 of the building code. And I'll read to you from that definition that equivalent facilitation is the use of designs, products, or technologies as alternatives to those prescribed, resulting in substantially equivalent or greater accessibility and usability. Substantially equivalent or greater. That's the finding that you must make to approve this, what you see in this photograph as an alternative. Consideration, note, and this is not a commentary note, this is a note that's in the code section. In determining equivalent facilitation, consideration shall be given to means that provide for the maximum independence of persons with disabilities. Okay, now, I anticipate you won't let me go into this, so I'm going to tell you that every city I have looked at in applying for this sort of alternate standard requires everything that I told you is required here. Bakersfield's handout, Berkeley's handout, Concord's handout and application, Long Beach's handout and application. I mean, the list goes on. The County of San Luis Obispo, again, they all require procedures, research, specifications for the consideration of the building official or the board, and this is all completely absent here. So, where is this heading? I think we've pretty much put to bed the issue of whether a demolition permit is going to trigger the code for that section. This is the health and safety code section that is applicable is 18938.5. That the standard is that is in effect at the time an application for a building permit is submitted, okay, and shall apply to the plans and specifications to the construction performed under that building permit. So that building permit,
thank you,
for the demolition permit.
We've heard what we can take.
Okay, I can tell you that I have not covered several crucial points.
Your time has been.
Your time's done.
That
You're over by 28 seconds.
I would appreciate an explanation why that other appellant was entitled to allowed to proceed for hours without being questioned, and yet this.
You don't have to respond to the question.
Listen, I'd like my meeting back if I could, please. We've given you time. If you want to apply for something later, please do. Please give us some idea how much time you need so we can decide whether we're going to be here for it. But the point is we need to move on.
All right, I would request either now or later no more than 12 minutes. I can cover the essential remaining points in that time. Or stop.
I disagree. We gave him 3 minutes. It's over.
Listen, sir, I'm done.
It's your prerogative as a board. You're making a decision for the city. I honestly,
I think we all. You're not reading this crowd at all. You really needed to summarize. You've been asked to do it repeatedly. You haven't done it. It's become an egregious behavior. You need to leave.
I'm truly sorry that you feel that way, Chair Langhorne.
Excuse me, your time in terms of the 5 minutes was cut off. Like I said, I take the onus on me. I didn't know the written procedures that were established separate from the municipal code that call for 5-minute time limits. You do have the discretion. That I take it from the commission doesn't want to provide any more additional time going forward for the appellant. Is that the answer?
If there's any time left after we've covered the rest of the business we have here.
No, you can't do that. It has to be in terms of the appellant presents this, because the next step is for you to make a motion in terms of the decision before you on there. So.
If we take no action, I don't think that's true, is it?
Well, if there's any more witnesses or any...
I'd like to hear some people.
Yeah, so right now the next step is to make either, if it's the conclusion, the next step is to either make a motion to accept, deny, or amend the standing motion, and then from there to open up to public comment, and then to vote on the procedure, on the motion before you.
And I'll just make my objection for the record of being cut off with no notice and contrary to the board's prior procedure in every appeal hearing that I've attended. And I don't think these rules have ever been put forth as rules before.
You've been given the floor. The floor is, your presentation is done. Not to sound rude at all, but the presentation is done. So the next step is for the commission to make a motion to amend, accept, or deny the standing motion before you, which is the code alternate for the property before 3732 State Street, the one-off application. The recommendation from the building official is to accept the code alternate. So now it's before you to make a motion whether to accept, deny, or amend that motion.
I'm just going to interject.
Excuse me.
I'm sorry.
Mr. We will have to ask you to leave if you keep.
Public comments are after. This is public comment. There needs to be public comment.
Yes, but this is not your meeting to run. Please.
I'm afraid that Mr. Jones has asked for a motion to be made.
Excuse me. A motion is to be made, and then, as I said previously, that is open to public comment after the motion is made, and then the board shall vote on the standing or amended motion. That is the process. I've explained that twice now.
Thank you.
Are we ready for a motion?
Ready for a motion.
I make a motion, we deny the appellate his appeal.
So the motion before, the standing motion before, the standing motion before the committee is the building, chief building official's recommendation to accept the code alternate or not. So the motion would be either to accept, deny, or consider an alternate of the chief, not the appellant's, but the building official's decision.
I make a motion, we accept the chief building official's interpretation as he sees it.
Okay, and then hold on, sorry. Now, there's no second at this point. Now we open up to public comment. I think there's 2 speaker slips.
Thank you. So we do have a motion on the floor to support the building official's position to deny the appellant, the appeal. We have 2 speakers on this. The first one being Jim Marston.
I first want to say that I do understand the concept of shared spaces. We've studied that at Georgia Tech where I taught. But this is not an appeal to understand whether we like shared spaces. Shared spaces are not mentioned in the California Building Code. They're not mentioned by the Division of State Architects. So that's a whole different thing than this panel should even try to understand. What we're here to do is to see whether these materials equally or better than what the code says. And I have a quick summary there, but first I want to ask Mr. Stuffer a few questions. What did your plan checker say about the plans?
In terms of this is just, I apologize, Deputy City Attorney John Dimas again. This is public comment, so that would be inappropriate in terms of public comment. You're allowed to make your comments in terms of this specific motion before you.
Okay, there's a lot of unanswered questions that I don't know about. I'm curious why the CASP representative for the developer hasn't presented a paper that says on his signature that he accepts that 3 foot is equal to 1 foot, that yellow is just as good as no contrast, that pebbles that have no specifications are just as good as a spec, and that no sound on cane is equal to a sound on cane. That's ridiculous in its entirety to think that those two things are equal. So I'm really upset that somehow you're making a decision that these materials are equal or better when all you've got is a letter from a former client at the Braille Institute. That's not a research paper. I have much more research experience than they do, but my comments don't matter either. It has to be done by a respectable professional board. If you want to have new electrical wiring, you don't just go to an electrician and say, is this good? You have to go to the UL labs and have them test this stuff. You can't just say, oh, I'm going to put some stones in here, and that's equal to the specifications. Because remember, there's four things: 3-foot, yellow, sound on cane, and the specs for the height, spacing, and all that stuff. None of that's been met. And then there were statements made in the comment that this was superior to the code, that the intent was not there. It's always funny that every time I bring a question up to the ADA coordinator, I'm always told, oh, we can't enforce intent, only the code. And now in this letter, both from Mr. Stuffler and from Brian, it says, oh, the intent wasn't to do this for a small street. So I'm just going to wrap it up. I wish we could hear from Mr. Hanson on why I don't see a letter from him stating as a CASP person that this is equivalent to, and I would so strongly suggest this group, if there's no proof, because I've called the Division of State Architect. They've never heard of this done. They laughed when I mentioned it. The CASP people don't think this is right. And if no one will sign their name to a letter saying that this is equivalent, I would say you're getting suckered into passing something that is not enforceable. And I won't go any further than that, but please think about your responsibility, and maybe, I don't know how liability works here, but I'm afraid for the condo board and stuff like that, because if there's an accident down there, they're going to know this city passed a law saying we're not going to follow the code. And I don't think this is the right place to do that. Thank you.
Thank you, Mr. Marston.
I have a question. If this is true, then how did the people up at the St. Francis project get their project done with the pebbles?
That's a very good question. That was designed before the 2013 code. So that was legal at the time in a multifamily condo development. This permit, the letter from George Estrella saying go ahead, was no good once the 2013 code took effect. So they... Pardon?
July 2015.
The code. I misspoke, yes. Once that was in effect, then that letter meant nothing. And also the letter from the Braille doesn't. But the point is that the other examples Brian did, those were legal because 11A did not exist. And that was a private residential multifamily. Does that answer your question?
Thank you, Mr. Marston. The second speaker, Bob, I'm going to butcher this name. Burnham, thank you.
Yes, sir. Where do I speak from?
You're fine. Somebody's right behind you.
Right to the chair.
Right here.
Oh, you mean sit down? Okay. That's okay. Chair Langhorn, members of the board, thank you for hearing me. My name is Bob Burnham. I'm a member of the Access Advisory Committee. I was privileged to meet with Brian Kernal and go on an on-site, hands-on test visit to 3 locations to test the difference between the truncated domes and the 1-inch, one foot pebbles. Now I'll show you just with my cane, when I make an arc like this and walk forward 1 step ahead, I could not detect the difference.
Be careful.
Yes, in the St. Francis and the Bella Riviera project, there are pavers in the driveway, and I could not detect any difference between those and the pebble strips. In contrast, over at the parking lot of the retinitis pigmentosa, I believe it is, in the eye center on East Mitchell-Terrena, California Retina Association. They have truncated domes, which are the 3-foot wide code regulated strips with sound on cane. Everything's in code there. What a contrast! I can only tell you that if I were to go into this project with this 1 foot wide of pebble strips, I would not feel safe walking on a roadway there within that complex, regardless of the frequency or infrequency of the traffic. I would not feel safe. And as an independent white cane user, totally blind, my primary concern is safety. So that's what I would like you to consider in these alternatives to what is code regulated and what should be proper and safe for the city in terms of your own liability as a board determining what's liable and what's in code for the city. Thanks.
Thank you, Mr. Burnham. Any further public comment? All right. We have a
Board Deputy City Attorney John Domas. There's the motion before the board, and it's open to vote in terms of you may discuss it, and the motion before the board currently right now is to accept the chief building official's recommendation.
We have a motion on the floor. Any questions, any comments?
Yes, I'm saying the motion's on the floor. Now it's open to vote. So you can have a discussion, and someone wants to second the motion, vote on it. So that's the process right now.
Okay, so we have a motion on the floor that has been seconded to uphold the building official's decision to deny what the appellant has brought forward. Is that clear enough?
No, the motion before the board right now is to the motion before the board is to accept the chief building official's recommendation regarding the code alternate for the property at 3732 State Street.
Does everybody understand that that is basically to deny what this cobblestone project?
No, that's not to deny it. That's to approve the cobblestone project.
Oh, so that's what we have on?
The department agreed that it was an alternate, and that it met code in their interpretation.
In the microphone.
Have you got it now?
I do now. I got to spin. I guess.
I mean, it's kind of a double negative thing here. Yeah.
I guess I do have some concerns of my own looking at this, and it has nothing to do with accessibility. It has everything to do with being able to get a fire truck in there. Planning circles generally use 10 average daily trips per dwelling unit. In a 72 of those, 72 units, I'm not sorry, 20. So that's 1,420 average daily trips generated on this road, this private roadway. And I needed to know that because I was always told you firemen need your trucks you need too big of streets. You're asking for way too much. I'm looking at this and I'm looking at cobbles that to me do not appear to meet the ability of supporting a fire truck. You've got a center line in the one-way street of 10 feet to the center line of the cobble strips to either side. I'm not comfortable with that at all. I'm looking at the fact that with these types of streets, to enforce parking, you need signage, which apparently would run contrary to this whole approach. My feeling is we're going to have a lot more cars on that street than you are going to have pedestrians, and we really need to consider that. So I am not going to support the motion to approve the cobblestones. Or the pebbles, excuse me.
It's open to debate in terms of the commissioner. So right now, public comments cut off, presentations are cut off. It's open to a vote. The one thing we do want to focus on is in terms of what's before the board. So if it's in terms of it doesn't meet the code or not meet the code, that should be the focus in the vote. Or if we can vote on that issue, and then if there's an approval, if there's not an approval, then you can make also a motion to amend to an alternate motion, so you have that decision. So
I see. Well, I do not believe that that section of Cobbles is code compliant, simply from the standpoint of fire code.
you go ahead,
Mr. Chair, Mr. Doimus, I don't know if this thing's working. I think we need to make sure that we have a basis for any motion or decision. So before the board, the way I understand it, Mr. Doimus, is that we have a code alternate for truncated domes separating a path of travel from a vehicular way. Whether or not the proposal will support a fire truck is not one of the evaluating criteria for this code alternate. That's a decision that's made elsewhere in the development process by the fire marshal when they look at the design. So the number of trips might impact the decision. I mean, if it's who really is going to make the most use of it. But it's my understanding, and correct me if I'm wrong, that the basis from the board, the basis for their decision has to be founded in equivalency to the truncated domes that are required, not the capacity of fire truck weight on a gravel or alternate proposal.
That is correct. That is the issue before the board right now in terms of that.
All right. Well, so is there any more discussion before we vote?
Oh, repeat the motion.
The motion again would be to support the building official's findings in favor of this alternate proposal.
Chair, you call for a vote in terms of the issue.
I was looking for other nods first, yeah.
President.
Sure.
Yes, sir.
Sure, of course.
All right, so votes on this?
So Commissioner, Board.
This is just a query. I might be ignorant on this point. I listened to his query about the domes and about his fire experience and what happens to fire trucks when they hit those things. And that is a big consideration also. And maybe if there's any possibility, just send it back to the City Planning Commission for further consideration. Is that a possibility, or do we have to vote a yes or no here?
The vote right now in terms of the issue is the approval of the, this is an issue, if I'm aware, and I can turn over the chief building official. This is not something that would go before the Planning Commission, am I correct?
That's correct, Mr. Doimus. So the decision before the board is to whether to uphold the cold alternate that I had approved as the building official. The design of the roadway, the capacity of the roadway for carrying trucks, vehicles, those decisions were all made during Planning Commission and design review, and they're all checked and confirmed during building plan check by the appropriate entities, the fire marshal and public works. So this decision is before the board is what I approve as a code alternate meet the durability, strength, those 7 criteria the code requires it to meet, to 3 feet of truncated domes. That's the real decision before the board.
Okay.
All right, so I think what we should do is vote the motion on the floor, and if it carries, then we've got that. Otherwise, we can come back for another motion.
Mm-hmm.
Or another motion. Yeah, you can vote, and then if that doesn't carry, then present another motion as well.
All right, all in favor?
I vote.
I would do a roll call for each commissioner.
Okay.
And then yes
Mr.
or no.
Wood?
All right, I vote to uphold the building official's ruling.
Bonnie?
I vote to uphold the building official. I vote to uphold whatever he said.
Okay, so 1 in favor and 1 opposed.
What? No, I voted the same.
My hearing's going too, so you're voting the same as he is. Thank you.
So for the record, it's the vote to uphold the, okay.
Yes. Juliet?
In favor?
In favor, and I'm opposed.
So we have the vote on the standing motion to uphold and approve the chief building's recommendation.
Yeah, thank you. All right.
1:30.
Second item,
What's this?
31 El Salito Road.
What's across street on State?
Appeal of the building.
I'm sorry, I didn't interrupt. We actually, board members, excuse me.
Brian?
Excuse me, we have another matter on.
Quick, get up. Stretch your legs.
All right. Do we still have somebody for 31? Thank you.
Okay. This one's gone away.
So now we have 31 El Salito Road, an appeal of the building official's decision to require a pool fence or an alarm installation per code requirement.
Thank you, Mr. Chair. As the building official, I'll give you the, similar to the prior item, there's a standing motion to uphold the decision of the building official. But let me, I want to share with you kind of the context of this situation, because this is a little unusual. There's a Swimming Pool Safety Act that the state established, and the city had its own swimming pool fence standards in 1981 that they adopted that were progressive. They were higher standards for pool safety, essentially raising the height of pool fences and pool barriers. What happened at this property is the building underwent renovations that had nothing to do with the pool. But in the course of those, the property owners can correct me if I'm wrong, in the course of those renovations, one of the gates that leads to the pool it was just falling apart. It needed to be replaced. So they replaced it. But there still are probably a couple hundred feet, literally, of fence that remained at its standard height. So we were in a predicament. It's like, so when someone replaces a fence that's at a height lower than we would allow, now we would say the whole fence has to go up, right? Because they replaced the whole fence. But in this case, they only replaced one gate in 100 or several hundred feet of fence. But by code, we can't say you can build it lower. The code doesn't allow us to do that. So we took the more conservative life safety approach and said the gate needs to be taller, needs to be higher, even though the rest of the fence around the pool is not going to be elevated. It's existing. And that's the decision that's before the board now was they're appealing that decision of elevating the height, replacing the gate with a gate of the proper height. I also should say I have the building inspector here. If there are questions from the board, Lauren's here. She can answer some of the more technical questions about inspection if there.
Thank you. Mr. Miller?
Thanks. Yeah, my name is Jeff Miller. I own the property with my wife, Kim. I brought a picture I took earlier. It might help show things a little bit more. You can see the gate Mr. Stuffler was talking about right up against the house there at the bottom. So the gate is right here. And the fence proceeds. The fence goes up the hill.
That red one right back behind.
Right.
The pool's back over this way.
The pool's back this way. So let me see if I have some. So here's just sort of, I captured this from some of the diagrams our architect did when we did the remodel here. The red line is the fence going up the hill.
Can you see this? No, I think we need. So why don't we move the camera more in front of the lady?
Sure.
I mean, the camera. Okay, can you see now? Yeah.
I got one.
Yeah, that's good. It's straight.
Could you just point it out for me?
So could I ask Mr. Stockman a question? Is the only thing you're requiring is the gate to be raised? You're not requiring the whole fence to be raised?
That's correct.
What?
No, that's not true. That's not, the notice of violation says the entire fence has to.
Let me read my email to the, and I'll apologize if I
thought I was the only one that got confused here.
automatic covers when the coolant's gone out?
We do not. We had that investigated. The way the pool is designed, we were told that it's impossible to put an automatic cover on it. It's raised on one end.
Did you have any consultants involved in your project at all? Land use consultants, a building professional at all? Anybody involved that?
We had an architect that did all the plans. I mean, as Mr. Stuffler said, that we didn't do any exterior remodeling on the grounds. It was all an interior remodel.
But you had a local architect that
We did.
would presumably be familiar with the rules?
Yes.
Okay.
But again, since we weren't doing anything in the exterior of the, one of the things we did do, the city requested that we put a fireman key on the gate box, which again, we weren't touching, but we did that. I felt we went the extra mile doing that, to be honest, since again, that wasn't part of the remodel, the plans that were approved by the city.
That's pretty standard everywhere, though.
I understand.
Mr. Chair, if I could respond to
Yes,
the
sir.
question. So here's my direction and it was included in the packet to count on the web and to the board members. March 23rd, 2016, to Mr. Miller. Our current property maintenance code requires pool fences to be maintained at least to a height of 48 inches or to the height required at the time of construction of their pool. We will be amending, Senior Inspector Lauren Anderson will be amending her notice to such that a 48-inch high fence and gate must be maintained in accordance with the attached swimming pool fence requirements from our property maintenance code. A building permit is required to be obtained for these modifications to the fence, and then it talks about planning approvals if necessary. So it's my understanding, and I think I documented it in the staff report, that the existing fence is 32 to 42 inches high. I'm not sure why it's that height, if it's the soil has been elevated from landscaping. As the pool fence requirements in 1981 when the permit was issued, I believe were 48 inches. So I'm assuming that with changing the grade around the fence, they can capture the 48 inches, get that height established. And then all they have to do is change the gate. But that is an assumption.
Yeah, I'm not sure how to respond to that. I mean, changing the gate to be 60 inches or 48 inches, I mean, I don't think we do it at 48 inches. I mean, if we're going to change it, we'll bring it up to the current code. But changing the gate to be that height with the rest of the fence being much lower, I think is not, it seems kind of ridiculous and certainly not aesthetically pleasing. So I don't know. That wasn't how I interpreted the notice violation, which specifically says a compliant fence and gate of not less than 5 feet in height will be required. And so that's what I'm going off of, was the notice of violation I got from your office.
May I see that?
So, yeah, we bought the house 3.5 years ago. At the time, the zoning information report, which we included in our appeal, made no mention of this issue, and it never came up. So just the backstory, we started this remodel in April of last year, went through the permitting process. This issue was never brought up at all until the final sign-off earlier this year, and which took us by surprise and we felt was very unfair, given that we just, from a financial standpoint, it would be very burdensome to replace a couple hundred feet of fence at this point, at least at this point in time. So that's why we're appealing. I just felt.
Are you familiar with a law called attractive nuisance?
No, ma'am.
I said, are you familiar with a law called attractive nuisance?
I'm not familiar with that, ma'am.
Okay, in law, it's related to swimming pools, and it takes the side of the person who gets drowned, like little kids jump the fence and all that. And I think your liability increases when you can't show the public that everything was up to current code on a swimming pool. Attractive nuisance law will come in and kill you.
I understand.
That's a personal opinion. It doesn't have to be on the record.
Yeah, my other point would be that, as Mr. Stuffler pointed out in the email he sent to us, the property does have a surrounding perimeter fence that's mostly 72 inches tall. There are places that are lower, the stone area, 42 inches tall. The actual fence itself is over 100 feet from the lowest part of the perimeter fence. And, you know, as you can see from the picture, most of it is on a steep uphill slope. Much of it is covered by vegetation. I think from a practical standpoint, the safety issues here are probably being overblown a little bit. I'm not arguing that it doesn't meet current code. I'm just...
Children.
Yeah, and we do live, again, as Mr. Stuffler noted in his email, our neighborhood is fairly sparsely populated. My wife and I don't actually have any children, so at least from that standpoint, I don't think that's as much of an issue for us. So I guess just to sum up what we're requesting, obviously we'd like this to be denied, but failing that, the city set us a fairly tight time frame to get this addressed. And again, after having just spent a lot of money on this major remodel, the timing is not great on that. So if the board isn't willing to overturn it, we'd like to at least ask for more time to come into compliance with the city's request.
Yeah, let me ask you, the perimeter of the fencing required for bringing up to code, what's the lineal footage?
Are you talking about the fence involved here? I believe, I didn't measure this personally, but going off our architect's drawing, I think it's around 110 feet.
Because, is it on a paper? I didn't read anything on that.
I don't think that was called out. I mean, Mr. Stuffler was speculating it was a couple hundred feet, but
you have an existing fence up now all around.
Yes.
Mr. Chair,
Property?
but before we use up any more of everybody's time, the notice of violation that has been issued is contrary to the direction that I gave Mr. Miller and that I gave staff, and I'm going to vacate or void the notice of violation. But I do want to also say that what you will receive will be an amended notice of violation to elevate your gate to a height of 48 inches. And we've encouraged you to consider elevating your whole fence, but we're not going to require that. So there's an error in our notice of violation, and now I understand. I was surprised when Mr. Miller said he wanted to have the hearing. I was thinking, wow, this is a 6-inch differential on a gate. That's a lot of time to spend on 6 inches, but maybe it's a major issue. But we gave him a notice of violation that is contrary to the direction that I gave him about 3 weeks earlier in an email, and the direction that I gave my staff for drafting the notice of violation. So they're here because we have officially told them that they need to have a 5-foot-high gate and fence, and that is not the direction that I gave staff, and that is not the direction I gave Mr. Miller. So I am voiding the notice of violation, which negates any need for an appeal hearing.
For the record, just what is the requirement for the fence, so we at least have that?
The amended notice of violation will say they need to elevate their gate and fence to a height of 48 inches. So
I just heard gate and fence again. That's why I'm confused.
Right. Well, that's what it says in my directive, but it's my understanding in looking at it, and we can, in fact, if you'd like to meet out there, we can, because it would be good to see what happened, why the fence is 32 to 40 some inches high. It just seems so odd. Usually they're kind of a uniform height, especially in the same run of fence. So, but 48 inches was a standard that was in effect at the time of the construction of the pool, and that's the standard you have to maintain.
So, but just to be clear, it's the gate and the fence that would potentially need modification. I mean, the fence is on a fairly steep slope, so I'm not sure what the engineering requirements there would be, but I can see how it would vary in height, potentially, from that standpoint.
Right. So if you want it, we can have the conversation
Sure,
after
at
the
this
board
point,
meeting, but,
yeah, at this point,
there's no need for an appeal hearing because I'm withdrawing the notice of violation.
Well, I mean, if it ends up replacing the whole fence and gate, we'll be back here again. That's not.
I don't think that's where we're at.
Sure. So for the record, well, let me just say one thing for the record. So for the record, the notice of violation from the City of Santa Barbara's Building and Safety Department has been withdrawn. So there's no order given by the chief of building official, technically as of right now, today, May 5th, 2016, to appeal on if the chief building does reissue a notice of violation, if that happens, then you have an opportunity to appeal that decision. But as of right now, there's nothing to appeal because there is no order given to you currently. So I think in terms of that, to go on and discuss any other issues outside of that would probably be improper at this point because there's nothing before the commission, technically speaking. So.
All right. Thank you for coming. I'd like to entertain a motion to adjourn. Second?
Second.
And so moved.
All in favor?
Aye.
But I'm really a big supporter of his too. So no, he is. I'm a huge fan.
So